Here with Dr. Nita Chhinzer, and in this episode we're discussing the principle of joint responsibility for safety applicable to all Canadian workplaces. All provincial, territorial, and federal jurisdictions have occupational health and safety legislation based on the principle of joint responsibility. The concept of joint responsibility is that there are implicit and explicit expectations that workers, supervisors, and employers collectively maintain a hazard-free work environment. What's the employer's role in this? In all jurisdictions, the employers are responsible for taking every reasonable precaution to ensure the health and safety of their workers. This is called the due diligence requirement. Specific duties include filing government accident reports, maintaining records, training and providing employee support for safe workplaces, ensuring that safety rules are enforced, posting safety notices and legislative information, and ensuring that the workplace overall is operationally safe. Recent court decisions indicate that employers must enforce safe work procedures through a progressive discipline process when workers do not follow safety rules. This is needed to establish a defense of due diligence. Let's talk about the supervisor's role in safety. Now, the term supervisor is used quite broadly. This includes people who may be in acting roles or lead roles, and it's somewhat surprising how little training they get on safety given the information that I'm about to give you. Most jurisdictions impose a personal duty on supervisors to ensure workers comply with occupational health and safety regulations. They place a specific obligation on supervisors to advise and instruct workers about safety, to ensure that all reasonable precautions have been taken to provide for the safety of all employees, and to minimize the risk of injury or illness. In fact, the individual supervisor can face a fine and even jail time for violations of these safety expectations. Let me give you two examples. The first example, in 2022, the director of a construction company in Metro Vancouver was sentenced to 14 days in prison, and his company was fined $25,000 after repeated workplace safety violations. These violations primarily concerned dangerous work conditions at heights without adequate fall protection. This case was significant because it demonstrated the court's willingness to impose jail time for severe or repeated violations and hold the supervisor accountable for that. Another example from Ontario was a refrigeration company. It was fined $20,000 in 2022 following a worker's death. The incident actually happened in 2020. But the worker suffered fatal injuries after becoming trapped between an overhead beam and the guardrails of an elevating platform. The court found that the supervisor failed to ensure the worker was properly trained to operate the elevating work platform, and that was a violation of the Occupational Health and Safety Act. Again, another example of where the supervisor was held individually responsible. This leads to the employee's role in safety. Employees are responsible for taking reasonable care to protect their own health and safety in the workplace, and in most cases to protect the health and safety of their coworkers. Specific requirements might be things like wearing protective clothing and equipment and reporting any infringements of the laws and regulations to management. For example, if there's a broken machine, that needs to be reported, or if you've been asked to wear protective glasses, it's your responsibility to wear protective glasses. Employees have three basic rights under the joint responsibility model in Canada. 1, the right to know about workplace safety hazards. The second, the right to participate in occupational health and safety processes. And the third is the right to refuse unsafe work if they have a reasonable cause to believe the work is dangerous. Now that's the one most people get confused about. Reasonable cause usually means that a complaint about a workplace hazard has not been satisfactorily resolved, or a safety problem places an employee in immediate danger. If the performance of the task would adversely affect health and safety, a worker cannot be disciplined for refusing to do the job. Let's take a look at some cases. A recent case in Newfoundland and Labrador involved an individual who was fired for violating a lockout procedure in a safety-sensitive workplace. The company was a mining company at a quarry. Due to the nature of the work site, the company prioritized safety by training employees regularly on safety procedures and monitoring the sites with numerous video cameras. They also prioritized safety in all of their literature and offered training on safety policies quite frequently. One particular safety policy involved locking or tagging out of a machine at the end of use. Specifically, locks were used to render a machine inoperable, and a tag was applied with the time and date of locking. This was required for any machine before performing maintenance. The company had fired people in the past for failing to perform the safety task, but one person who was fired sued for wrongful dismissal. And despite having no prior discipline, the arbitrator here upheld the dismissal, emphasizing the importance of adhering to safety protocols. There's also been cases of employees fired for repeated failure to wear protective equipment that have been upheld by the courts. In the Canadian Joint Responsibility Model, there's also joint health and safety committees. The function of these committees is to provide a non-adversarial atmosphere where management and workers can work together to ensure safe and healthy workplaces. Most jurisdictions require a joint health and safety committee, usually if there's a minimum number of employees. The committee is generally responsible for regular workplace inspections to identify potential health and safety hazards, evaluate the hazards, and implement solutions. Hazard control can be achieved by addressing the safety issues before an accident or injury happens, but also includes identifying ways to prevent a hazardous situation from harming workers and establishing procedures to ensure the potential hazard will not recur. Health and safety committees are also responsible for investigating employee complaints, accident investigations, developing and promoting measures to protect health and safety, and disseminating information about health and safety laws and regulations. The model of joint responsibility for employee safety in the workplace holds all stakeholders accountable to minimize harm done to employees.